Good afternoon, everyone. I'm Kelly Marks, your 2021 NC Realtors president. I'd like to welcome all the broker in charges, our association executives, and anybody else who may be joining us today. So thank you very much for spending the time with us. We're going to be recording today's session, and we'll send all of you a link to the recording in the next few days. So please make note of any of the questions, and we'll take those via chat at the end of the session. There's so much change right now and so many areas for potential risk. Today's session is packed with information on what programs and services are currently available to you and your agents. And with information on that, the programs that NC Realtors is developing to reduce your risk as a broker in charge. We hope the information received today will be valuable and will provide you with needed resources to implement or expand on fair housing training at your firm. And of course, you know that's one of our main focus is for the 2021. NC's Realtor is committed to supporting you in these efforts. So let's begin today's session with important updates and resources about training provided by your state association. So we're excited to announce that NC Realtors is developing a new fair housing training video series for all of our broker in charges that will launch this June. We're building a full on-demand plug and play curriculum on fair housing that you can use as a tool to educate your agents during meetings, onboarding, and annual training within your firms. The curriculum will include short videos with a credible lineup of speakers, interviews, question and answers, assignments and resources that include additional training case studies and more. The nationally known instructor, Jenny Field, will be our MC throughout this training series. And with almost 30 years of experience as broker in charge herself, she's giving us the inside scoop to make sure that we give you everything you need in order to make this training series not only user-friendly, but also a truly valuable training asset for your firm. Some of the guest speakers during the training series include Brian Green, Alexis Smokeler from NAR, Bo Pattern from the Long Island Board of Realtors, Nate Johnson, who is a nationally recognized instructor on fair housing, as well as our own general counsel, Will Martin. Be on the lookout for additional information in the coming months as we prepare to launch this plug and play training series for all of you. Now, as a quick side note, Nate Johnson's also leading a 4-hour CE course called Focus on Fair Housing. This is occurring on April 14th and for only $15 for NC Realtor members. This is a great opportunity for your agents to stay current on fair housing laws while earning a CE at a great price. Seating's limited, so please jump on this opportunity. We'll include registration information on this class in the email that we'll be sending you after today's session. So as part of NC Realtors' commitment to diversity and inclusion, we're excited to partner with the Diversity Movement. That's located in Raleigh, and to help us on diversity, equity, and inclusion journey. The Diversity Movement has also recently partnered with the South Carolina Realtors. As you know, they're in our region. The Diversity Movement was created by a core team of innovators, diversity practitioners, business experts, and marketing leaders to equip individuals with the cultural readiness and tools to thrive in the global marketplace. In order to embed diversity, equity, and inclusion into the core of doing business, the Diversity Movement provides consulting services, as well as comprehensive and engaging e-learning, customized training, and content. So over the past weeks, we've been sharing background information on NC Realtors within the Diversity Movement, and we'll have a formal kickoff meeting next week. Following this kickoff, Dr. Holland with the Diversity Movement will be conducting listening sessions, which are approximately 1 hour each, with our staff as well as with regional membership groups to gain qualitative insights. The Diversity Movement team will then create an insights report based on their findings and work collaboratively with NC Realtors to establish our own DEI mission, vision, and values, as well as long-term DEI strategy. So in addition, we'll be offering 2 training sessions for our association executives so they have a better understanding of DEI. We'll also be providing access to the Diversity Movement's Foundation Learning course, which is Diversity Beyond the Checkbox. For 20 of our staff members, the 5-module course explores different types of diversity and helps you to identify and mitigate unconscious bias, among other learnings. In 2021, 2 of our diversity committee members will also become certified diversity executives through more intensive training offered by the Diversity Movement. We look forward to engaging with the Diversity Movement on our journey to further infuse DEI into our own business practices and culture. And we'll keep all of you posted on this journey as it develops. I know there's a lot of information to keep up with, and that's why NC Realtors has created an online library of fair housing tools and resources at ncrealtors.org/fair housing. Again, ncrealtors.org/fair housing. Here you'll find NC Realtors Fair Housing webinars, courses, resource links, to even more training tools in our own diversity inclusion commitment statement. There's even a quick link to NAR's Fair Haven training program. If you haven't yourself taken on the Fair Haven training program, we'll be talking a lot about that today. And this is a great segue into another exciting announcement. And that is, I hope you've all heard of Fair Haven by now. As just mentioned, at the end of last year, NAR launched a Fair Haven Realtor and an innovative online simulation training training session where agents work against the clock to sell homes in the fictional town of Fair Haven while confronting discrimination in the home buying process. It only takes an hour. It took me actually less than an hour. It may take some of you an hour, maybe a little bit longer to complete, but it is really a terrific way to fully understand and walk in the shoes of home buyers facing discrimination. So today, NC Realtor is proud to launch our Visit Fair Haven Challenge. And that's a contest that encourages all the NC Realtors to complete the training for a chance to win some fun swag. And if you know me, you know it's all about the lovely parting gifts. So we do have swag available and out there for those who complete it. We've even got additional incentives for you, our BICs, if all of your agents complete the simulation. So if all of them complete the simulation, then you're eligible to win one of three $1,000 cash prizes. And that's to enter. You'll just need to submit a simple form verifying that your agents have completed the training. The challenge is going to be launched April 1st. So it'll run through September 30th. And then we'll announce the 3 winning firms at the annual convention in October. And yes, we are going to have our annual convention in October, and that's going to be in Wilmington. Very excited about that. It's been a long time since we've all been able to get together. Fair Haven is a great way to implement fair housing training at your firm. It's interactive, as you mentioned. It showcases your firm's commitment to equal professional service for all. So reduce your risk. Have your agents visit Fair Haven this year. We'll send you all the formal contest detail after today's session. So I know I've shared a lot of information with you. So let's just kind of recap. 1, NC Realtors is releasing a new fair housing video training program for BICs in June. 2nd, NC Realtors is working with the diversity movement to further infuse diversity, equity, and inclusion into our business practices and culture. 3, NC Realtors is launching the Visit Fair Haven Challenge on April 1st, which for all firms have a chance to win one of 3 $1,000 cash prizes, in addition to some fun swag for all the participants. And you can find all these resources and more at ncrealtors.org/fair housing. And again, look for additional emails after this session today. So enough about everything that's going on with us. I'd now like to introduce our first guest speaker, which is Alexis Smokeler. Alexis is a senior policy representative for fair housing at NAR, and is here to talk more about Fair Haven and why it's so important for all realtors to take the time to go through the training. Alexis, thank you so much for joining us. We're very excited, and like I said, huge fan of Fair Haven. Had so much fun with it.
Thank you, Kelly, for the introduction. Good afternoon, brokers in charge, AEs, and all of our friends in North Carolina. My name is Alexis Smokeler, and I'm the Senior Policy Representative for Fair Housing at NAR. My position is new. I am part of a fair housing team at NAR that did not exist 18 months ago. NAR is investing a lot of resources into fair housing. We're making it a priority. And you're going to be hearing a lot more from us on fair housing in the coming months. So I am here to be your fair housing resource at your national association. And I encourage any of you to reach out to me with your fair housing questions, ideas, and concerns. I'm putting my email in the chat box. And please watch that chat box because I'll be posting links throughout my presentation. So today I'm going to give you an update about what we've been working on over the past year at NAR to advance fair housing, and tell you about some of the new resources and programs we've developed. And then I'm going to give you a little peek into Fair Haven, our new training. So first, a bit of background. A little over a year ago, NAR created a new Director of Fair Housing Policy position and hired Brian Green for that role. Brian was previously the Chief of Fair Housing Enforcement at HUD. He's one of the most knowledgeable and committed people out there when it comes to fair housing. He's a great asset to NAR and to all of us. So 3 weeks into Brian's tenure at the end of 2019, the industry was rocked by the Newsday investigation of discrimination by real estate agents on Long Island. If you're not familiar, Newsday was a 3-year investigation using matched pair testing to look at how the top brokerages on Long Island treated clients of different backgrounds. I expect most of you are familiar with discrimination testing. There are 2 testers posing as clients, kind of like mystery shoppers. They both have the same qualifications. They're even dressed the same. And they're both looking for the same kind of house in the same general location. The only difference between them is their race or national origin or whatever other prohibited basis is being tested on. They each go into a brokerage separately to see what kind of treatment they receive, and then fair housing experts compare that treatment. Courts consider testing evidence to be some of the most persuasive evidence a plaintiff in a discrimination case can bring. After its 3-year study, Newsday didn't take its findings to court. They could have. Instead, they published them. And what they caught on hidden camera was that real estate agents treated the white tester and the tester of color differently in 40% of interactions, almost half the time when the tester was Black. Agents showed them fewer listings. They steered them to different neighborhoods based on their race or their national origin. They required some to be pre-approved to see listings and not others based on their race. They told them different things about crime and schools. I would encourage you, if you haven't watched the documentary yet, to check it out. It's eye-opening. It's really a case study in what not to do if you want your agents to stay on the right side of fair housing law. I'm posting a link in the chat box for you there. So after the investigation was published, the New York State Legislature launched hearings, subpoenaed agents and brokers, and a raft of legislation has been introduced this year in New York to combat real estate discrimination. So at NAR, 3 weeks after Brian came on board in this new fair housing director position, Newsday kicked everything into high gear for us. We had to respond, and we launched our ACT Fair Housing Initiative. ACT is an acronym. The A stands for accountability, the C is for culture change, and the T is for training. It's a package of industry reforms and tools for members, associations, and brokerages, shoring up our own house. Part of it is to make sure we're holding ourselves accountable when fair housing laws are violated, but also we want to shift hearts and minds so that equal service is something that is woven into the way we serve consumers and the public. So that when we say realtors hold themselves to a high ethical standard, upholding fair housing is core to that. And what we're telling brokers and AEs and realtors is that yes, fair housing is the law. Yes, it is the ethical thing to do. But also, making homeownership available to the broadest possible group of qualified buyers is good for your business. It's good for your community. It's good for our economy. Nationwide, homeownership growth over the last 10 years has been driven by Hispanic Americans. Posting a link to that study in the chat box. There are millions of qualified, mortgage-ready Black and Hispanic millennials who are ready and able to purchase a home. That market is not being served. The racial homeownership gap, a 30-point gap between Blacks and whites, it's the same as it was in 1968. the year the Fair Housing Act was passed. Posting some more links for you here. So what happens if we do nothing? What happens if we allow discrimination and segregation to continue? Well, it's really essential to understand that when discrimination deprives qualified buyers of housing opportunities, that isn't something that just hurts other people or disadvantaged groups. It hurts all of us. Morgan Stanley came out with a study last year showing that discrimination stopped 5 million qualified buyers from owning homes, cost nearly 800,000 jobs, and stopped $400 billion in tax revenue from going to our governments. Another recent study found that in the Chicago metro area alone, housing segregation is costing that economy $8 billion a year. Why? Because when people can't access the intergenerational wealth that comes from homeownership, when segregation keeps people from living near good jobs, when kids can't access all the resources they need to become productive citizens, all that potential is lost. The entire economy is held back. The size of the pie is decreased for everyone. So let's talk about what NAR is doing to advance homeownership in the neighborhood of choice for all qualified buyers, regardless of their background or identity. ACT. The A is for accountability. NAR is creating a self-testing program for brokerages who want to voluntarily test themselves for discrimination. This will allow them to uncover and address problems before a newspaper or a private fair housing group uncovers them. We're creating a methodology that will allow interested brokerages to raise their hand, say they want to do it, and then plug and play. They'll be tested, receive a confidential report of the findings, and then have access to training and other remediation measures to correct whatever problems, if any, are uncovered. And I want to note that in Newsday, 12 brokerages were tested. There were findings against 10, but 2 of them had no findings. They were doing something right. Also on the accountability front, we're engaged in a review of the real estate licensure laws of all 50 states. We're looking at enforcement of fair housing violations, and we're also looking at fair housing education requirements. We'll be working with AEs in states who want to make those laws stronger. We've uncovered a lot of variability across the states. The next 2 prongs of ACT, culture change and training, are interwoven. We're very excited about a video series we're about to launch of Realtor fair housing champions who embrace fair housing as part of their business strategy. That's a series that we want to continue adding more stories to. And we're going to be finding additional ways to acknowledge realtors who are fair housing leaders, to help shift the culture of our industry to one that applauds and celebrates fair housing. We're also introducing new and innovative training opportunities for realtors. So last June, we released a 50-minute training video on implicit bias in real estate, which is available on our website. This was part of the Charlie Oppler challenge that some of you may have already participated in. I just shared a link. Implicit bias is the way that our brains automatically and often without our conscious awareness associate stereotypes with people who are different from us. So that even as our conscious minds reject discrimination, and even as we hold up fairness and equal treatment as cherished values, our unconscious minds may be causing us to treat people differently or unfairly without our even intending to. This training offers practical tools customized for the real estate context to help us identify and overcome these hidden biases so we can treat all customers fairly. Following up on that video, we're launching a 3-hour classroom course on implicit bias that goes even deeper with more exercises and more tools to help us check our own biases. We're piloting that training in 3 states where it will be offered for CE credit. And then back in November, we launched Fairhaven, a fair housing simulation. Fairhaven is a new approach to fair housing training. There isn't anything else like it. We decided to create it not long after Newsday was published. We saw in more than one of those hidden camera videos, agents referencing their fair housing training. They talked about what they weren't supposed to do. And then they went ahead and did it. Something wasn't connecting. We could see that we needed a new kind of fair housing training, one that teaches not only the substance of fair housing law, but that would also move more agents to embrace it. And that's how we came up with Fairhaven. It's an immersive simulation experience that uses the power of storytelling to affect the learner's emotions. In real estate sales scenarios inspired by real fair housing cases, learners will confront discrimination from the point of view of an agent and a client and choose how to react. So now I'm going to give you a little peek into Fairhaven. Let me share my screen here. Here we go. All right. The fictional town of Fairhaven is a beautiful place. Modern design, gorgeous graphics. It's a pleasure to be there until you run into all the discrimination going on. Learners in this fictional town take on the role of an agent. Their goal is to sell 4 homes in 6 months. As they work against the clock to close deals, they encounter different kinds of discrimination. A seller backs out of a deal after learning the buyer is Black. A condo board won't let a buyer in a wheelchair build a ramp to access the lobby. You're hosting an open house with prospects of different backgrounds. Did you treat them all the same? Learners will reach decision points as they interact with clients and colleagues. Those decisions affect the outcome. If the learner's choices align with fair housing principles, she gets a sale. If they don't, she'll have an opportunity to course correct. She'll get fed more scenarios and have more opportunities to close deals until the time runs out. Along the way, learners will have the opportunity to click out to view additional resources if they want to learn more. Now, sometimes in Fairhaven, we flip the script. Now you are a client on the receiving end of discrimination. Your agent was really nice to you on the phone, but when you come into the office and she sees the color of your skin, her demeanor changes. When an agent learns you're gay, she discourages you from moving into a residential neighborhood. Your agent keeps trying to steer you to a neighborhood where people of your national origin live, even though you've told them it's a long commute to your office. Each client point of view scenario is followed by video testimonials from real people who have experienced housing discrimination. With these powerful stories, Fairhaven aims to affect learners' emotions, to open them up to see and even feel the harm that discrimination causes in real people's lives. With this training, we ask learners to open their eyes and their hearts, challenge some of their own biases, and motivate deep reflection and ultimately behavior change. We've set the bar high with Fairhaven. It's our goal for learners to come out of this experience seeing the world in a new way. And we hope that the combination of Fairhaven's two essential elements, practicing what to do when confronted with discrimination and gaining more empathy for people who lose a housing opportunity because of discrimination, will set them up to go forward having fully embraced both the letter and the spirit of fair housing, and feeling ready to confront these situations and know how to do the right thing for their clients, for themselves, and for their communities. The feedback we've gotten from the thousands of learners who have already completed Fairhaven has been overwhelmingly positive. A learner told us that the training motivated her to stand up for her clients in situations where she felt something was wrong, but otherwise might not have wanted to rock the boat. Another learner said he got angry when he felt like the client who was being discriminated against. Others described feeling tearful as they watched the client videos. Several learners told us that they'd seen similar situations and they hadn't known what to do, and that Fairhaven had given them the tools to know how to confront these situations. Fairhaven is available for free to all NAR members at fairhaven.realtor. I'm posting the link in the chat box, along with a link to our Fairhaven marketing assets. And I also want to mention that it's available as a software package for your in-house learning management system. So I'm about to turn it back over to Kelly, but before I do, a quick plug for some of our upcoming Fair Housing Month events and assets. By March 29th, but possibly sooner, we will be putting up a package of Fair Housing Month assets for you, a poster, social media assets, email header, and so on. They will be available at this webpage, which right now has last year's Fair Housing Month assets, but will soon be updated. And then on April 15th, we're co-hosting an event with the Martin Luther King Jr. Memorial Foundation on the past, present, and future of fair housing. It's going to be narrated by Soledad O'Brien, and our invited guest speaker is HUD Secretary Marcia Fudge. I think we're taking questions at the end. So Kelly, back over to you. Thanks.
Alexis, thank you so much. Just a terrific presentation, and hopefully the broker in charge has got something as far as out of it. It's certainly the agents need to participate and go online and do the Fair Haven. So very exciting. Like I said, I thoroughly enjoyed it. So most of you know our next presenter, Will Martin, who's no stranger to any of us at NC Realtors. He's our general counsel. Will's going to share the latest legal issues impacting firms like yours and basically what you can do to reduce your risk as a broker in charge. So at this point, I'd like to turn it over to Will.
All right, thank you, Kelly. Hopefully everybody can hear me and see me. I'm not seeing myself on the screen yet, but am I being heard?
You are being heard and seen.
Okay, terrific, terrific. All right, good afternoon, everybody. As Kelly said, I've had the great privilege of being NC Realtors General Counsel nearly 25 years now. It's just amazing how time flies. And I've been asked to address about a half a dozen items, any one of which I could easily speak about for an hour. So I will try to get through these topics, which include escalation clauses, appraisal clauses, Zillow's recent activities, the settlement of the lawsuit by the Department of Justice against NAR, new standard of practice 10-5, which is under the Fair Housing article of the code, rental assistance, and a little bit about the legal hotline. So, use of escalation clauses. You know, we've been getting questions about escalation clauses for years, on and off. I can distinctly remember the first question I got about an escalation clause, and it was somebody that was moving here from New York, and their New York lawyer suggested that they include an escalation provision in their offer. And so I got a question from I don't know if it's the buyer agent or the listing agent, about this creature. And I'd never heard of them before. And I remember talking with one of the real estate commission's lawyers, Marilyn Tomei, who's been gone from there for at least 20 years. So this was at least 20 years ago that I got my first question about escalation clauses. And so they've been waxing and waning over the years, but there's been a recent sharp uptick in the number of questions that we have fielded about escalation clauses on the hotline, undoubtedly driven by the historic real estate market we've been in, which has impacted a lot of different areas. It's put a lot of stress on a lot of our forms and practices. Multiple offer situations are getting more and more intense. The reappearance of escalation clause questions is all part of that. Escalation clauses are not illegal or unethical, but they can be problematic for a number of reasons. And so they've been historically discouraged by the Real Estate Commission and by the North Carolina Realtors. I wrote an article on escalation clauses in, I think it's 2012 or 2013, that I've sent to a bunch of people. I'm still sending out that article. And it says, I think at the end, that, these things aren't illegal, but they really are discouraged by the commission and by NC Realtors. And I don't really think that's changed. I became aware just the other day that the commission is apparently working on an article for the bulletin, which I really welcome, to get their position on escalation clauses in writing, because that's one of the issues. But just a couple of the issues that I think make them problematic. How can a buyer who includes a provision in their offer that they will pay, say, $1,000 more than any other bona fide offer the seller receives, be sure that the other offer that triggers the escalation clause is actually a bona fide offer? You really don't know. If the escalation provision requires that the seller share a copy of the offer that triggered the escalation clause, which I believe it should, could the listing agent get in trouble with the Real Estate Commission for disclosing the terms of an offer to a competing party? That's the commission's offer shopping rule. Also, if the escalation clause includes a maximum amount that the purchase price can escalate, which I think you'd be crazy if you were a buyer not to include a maximum, what's to prevent the seller from countering the buyer's offer at that maximum price? And I could just go on. If you're interested, I'd be happy to send you the article I wrote that I think gets into a little bit more depth about escalation clauses. Bottom line, though, as I said, they're not illegal or unethical. And if a buyer insists on including an escalation clause in their offer, a lawyer must be involved in drafting the clause. Would it be okay? NC Realtors Forms Committee has been asked to develop an escalation addendum and has declined to do so. It's actually a standard form in a number of states, but we just don't have one. So would it be okay for a firm to engage an attorney to create an escalation addendum or an escalation clause that the firm's agents could offer to a buyer who wants to include it in their offer? My answer to that question is yes. If you do that, though, you really need to make sure your agents have a good understanding how the provision works. There's nothing worse than giving your agents a form and having them throw it at a transaction and they don't really understand the effect that the form has on the transaction. So if you're going to have a form, you need to do some good training to make sure your agents understand how it works. And you also need to hire a good lawyer who's going to do a good job with the form. I've seen quite a few of these escalation clauses, and believe me, some are better than others. they tend, as a general rule, to focus almost exclusively on the price term as a way of triggering the escalation clause. But there are other things that need to be considered too, to ensure that you've got an apples to apples sort of a comparison between the offer containing the escalation clause and the offer that triggers the application of the escalation clause. One very quick example, an obvious example, would be that you want it to be the net purchase price, not the gross purchase price. Else you might have your offer escalated, the purchase price escalated by another offer where the net is actually less than the offer that your client has made. So that's just one example of the things that need to be considered if you're going to include an escalation clause in an offer. Appraisal clauses, this is new. It's obviously driven by the market we're in and the willingness of buyers to enter into contracts at purchase prices that are well above what the property is probably going to appraise for. And so we've been getting a lot of questions about the use of so-called appraisal clauses, and we've been provided copies of several such clauses. And the ones I've seen, they're all a little different, but they say something to the effect that the buyer promises, cross my heart, hope I don't die, promises they will complete the transaction even if the appraisal is less than the purchase price. And they'll make up the difference in cash or other immediate or readily available funds, and that they've got the funds. But that's about what they say. And if that's essentially what it says, I've been telling people that I don't think that adds anything of substance to the contract at all. Because once the due diligence period is over, as you all well know, there is no appraisal contingency in the standard offer to purchase and contract that would permit the buyer to terminate the contract based on a low appraisal, unless it's an FHA or VA financing situation. So once the due diligence period is over, the buyer is already obligated to complete the transaction and doesn't have any basis for walking away. So the promise that they won't walk away really doesn't add anything. It's really illusory, I would say. And let's say that buyer who has promised to complete the transaction, even if the appraisal is low, decides to walk away anyway, the seller is still limited in what it can recover according to the offer to purchase and contract. That would be the amount of any due diligence fee and earnest money deposit that the buyer owes. So I really question the efficacy of a form like that. But if, I've had people tell me, hey, I understand what you're saying, but, I've been told that unless my buyer's offer has a provision of this type in it, that it's not going to get serious consideration by the seller because we're going to get 10 other offers, and, all these other offers are going to have a provision like that attached to the contract. And I say, fine, if you're going to feel the need to use a provision of this nature, it's got to be drafted by a lawyer. Please, please don't try to draft this yourself. Kind of a related question I've gotten about this and escalation clauses. It needs to be drafted by a lawyer, and maybe it's a good idea for the lawyer's name to be on the bottom of a form that the lawyer has drafted. It's not a legal necessity, and whether it is or it isn't, the listing agent is required to present an offer, the seller can certainly choose not to accept it, but the listing agent's required to present it and can't say, well, the lawyer's name is not on this form. How do I know it was created by a lawyer? I'm not going to present it. That's the one thing that could get you into trouble, because you're required ethically and legally to present all offers right away. And I have a special concern about using a form or a provision like this for listing agents, because I really think the seller should understand that if the provision is like the one that I've outlined, the seller really ought to understand that this doesn't add anything to the seller's rights. This is not going to cause the buyer to be required to perform the contract any more than they're already required by the pre-printed wording in the offer to purchase and contract. So that's what I've got to say about those two topics. Zillow's acquisition of Showing Time, Zillow's entry into the marketplace as a real estate brokerage firm. That's, Zillow is in the process of acquiring Showing Time. Last time I checked, it wasn't finalized yet. I think if it hadn't been approved, it's still going through some regulatory compliance process. As I said, Zillow's also entered into the marketplace as a licensed real estate company. Zillow also owns Dotloop, which is a pretty popular form software program for NC Realtor members. So obviously Zillow's increasing its presence in the real estate brokerage industry in a very big way. And this naturally causes concerns in the industry about the impact that Zillow's increased presence is going to have. And I don't want to talk about that so much as put my lawyer's hat on here and just remind you of a couple of things that you need to be aware of if you're inclined to voice your concerns about Zillow and what Zillow's up to. Article 15 of the Code of Ethics provides that a realtor can be disciplined under Article 15 of the code for knowingly or recklessly making false or misleading statements about other real estate professionals, their businesses, or their business practices. And, as I said, Zillow is now in the business. And so you need to be careful if you're in what you say about Zillow, and make sure that what you say is truthful and not false or misleading. The other concern, the big concern for me, is the possible application of the antitrust laws. And you're lucky you're not going to get my sermon on antitrust laws that I give to the board of directors at their first meeting every year. But, it's fine for you and your business to respond to the entry of a new competitor in the marketplace, however you want to, as long as you're doing so lawfully and you're acting in the best interest of your client, and it's fine to vigorously compete with that new competitor. But what you can't do is reach any sort of agreement, whether it's express or implicit, with one or more of your fellow competitors on how you're going to respond to this new competitor in the marketplace. That very well could be characterized group boycott, which is a per se violation of the antitrust laws. The working definition of an antitrust violation that former NAR General Counsel Lori Janet gave me many years ago is an antitrust violation. It's an agreement among competitors that restrains trade in an unreasonable way. So there are really four elements. And you all are probably, many of the people on this meeting are competitors with each other. Maybe not all of you, but you ought to assume you're competitors. And so you're halfway to an antitrust violation just, when you talk to each other. So you need to be careful about what you talk about. And so as a general rule, you should really avoid conversations with a fellow competitor relating to the business practices of another one of your competitors or the appropriate response to this new competitor. And that's all I'm going to say about the antitrust laws. The Department of Justice settlement, as you all know, the Department of Justice sued NAR, I guess it was last year. I know it wasn't this year. I think it was last year, primarily over some of its MLS rules that the suit alleges impose unreasonable restraints on trade in violation of the antitrust laws that we were just talking about. NAR has agreed to settle the suit and is still working with the Department of Justice on the details of the settlement. They said 45 days when this was announced late in the year, and it's been a good bit more than 45 days already. So I don't really have a feel for when that's going to happen. But once the details are worked out, the settlement has to be approved by the court where the suit was filed and by the NAR Board of Directors. So, nothing's been finalized yet. Once everything is finalized, I've been told that NC Realtors is going to schedule a webinar to discuss this topic in detail, and that the NAR legal department is going to be a part of that webinar. So stay tuned for that. According to what's available on the NAR website, we anticipate 4 rules changes as a result of this settlement. MLS offers of compensation will have to be disclosed on public-facing websites maintained by an MLS. An MLS can't restrict subscribers from displaying offers of compensation. And the offer of compensation is going to have to be disclosed to clients before an offer is presented on a listing. That really shouldn't be a big change for us in North Carolina, because our real estate commission's rules already require that the client be aware of how much is being offered in cooperative compensation up front. Real estate services cannot be advertised as quote unquote free. MLS listings can't be filtered based on the amount of compensation or the name of the listing broker. And perhaps most significantly, lockbox access will be required to be available to all licensed real estate agents, whether they're a member of MLS or not, with the seller's prior approval. So those are the basic changes that you're gonna see as a result of this settlement, or so we think at this point. Moving on to the next topic, Standard of Practice 10-5. NAR adopted a new standard of practice under Article 10 of the Code of Ethics last fall. It is intended to help curb mounting complaints about realtors posting discriminatory speech online, especially on social media. And so Standard of Practice 10-5 prohibits the use of harassing speech, hate speech, epithets, or slurs based on any of the 9 protected characteristics. There's 7 that are required under the fair housing laws at state and federal level, and 2 that are part of the Code of Ethics that kind of go beyond what's required under state and federal fair housing laws. Sexual orientation and gender identity. Perhaps just as significant is the revision to Statement of Professional Standards Policy, number 29. Prior to last fall, Statement of Professional Standards Policy 29 stated that a realtor was only subject to disciplinary action under the code with respect to real estate related activity. But as revised, Statement of Professional Standards Practice number 29 now provides that a realtor will be subject to discipline under the code with respect to all of their activities. Now that doesn't, when I first saw that was being considered, I thought, wow, they're really throwing the doors open here. But after I thought about it a while, if you go through the code, most of the 17 articles of the code are pretty narrowly tailored to real estate related activity. And so, this doesn't really change that. But there are a couple that I think it's going to broaden the application of the code. And that was intended actually with respect to this new Standard of Practice 10-5, because if you put those 2 changes together, if a realtor uses hate speech, harassing speech, epithets, or slurs based on any of the 9 protected characteristics, that's important. It's got to be speech that's based on any of the protected characteristics, he or she is subject to discipline under the code, even though the hate speech, harassing speech, epithets, or slurs were not used in connection with real estate related activity. Now, to help guide members in understanding how Standard of Practice 10-5 is supposed to be applied to the conduct of realtors, what's the scope of it? In particular, association grievance and professional standards committees that will be called on to handle complaints alleging violations of Article 10 based on this new standard of practice. There's a new appendix in the Code of Ethics and Arbitration Manual, which is the Bible of procedures that a local association uses in handling ethics and arbitration cases. And this new appendix goes into some detail regarding the appropriate interpretation of Standard of Practice 10-5 and Statement of Professional Standards Policy 29. You know, if you're interested, you can get the access to the Code of Ethics and Arbitration Manual on the NAR website. Just go to Code of Ethics and kind of keep drilling, and you'll happen upon it. And I can tell you, in the 2021 version of the manual, this appendix is on page 79. NAR has also produced a series of training videos that give the rationale and an overview of the new policies. Those are also available on the NAR website, and I'm not sure if I'm smart enough. I'm going to try to post a link to those videos in the chat box here in a second. But let me move on. I'm running out of time here. The hotline. I was supposed to put in a plug for the hotline. We handled close to 6,000 hotline questions last year between me and my two law partners, Bill and John. And this year, it's been going up every year since we put it back in as a member benefit. There was a period of a couple of years there back in the it was like 2012 or so, when we were still experiencing the effects of the Great Recession, where we got the bright idea of making it a sort of an add-on that you had to pay for, $100 a year. It was a pretty reasonable price, but things got a little bit better, and so NC Realtors figured out how to put it back in the budget, so it's a part of your membership dues. I think a great program, not because, you know, I'm on the receiving end of these questions, but I just think it's great that you've got the ability to reach out to attorneys who have collectively, I mean, decades of experience handling the kind of questions that you all get. The email address is legalhotline@ncrealtors.org, legalhotline@ncrealtors.org. That's probably the best way, since the staff is still working remotely at NC Realtors. Send us an email, and if if it's a complicated thing we need to talk about, just say, hey, I've got a question, can you call me, and give us your number, and we'll give you a call and we'll talk about your question. Just for grins, I looked at I had the hotline duty yesterday morning. I had 21 yesterday morning. That's a little above average. And I went back and, we take some very brief notes on the nature of the question that we get. And I went back just for grins and looked at the questions that I got yesterday. And a lot of these questions, kind of cross, these boundaries. But I characterize 4 of them as forms questions. Which form do I use? How do I complete it? 4 of them were contract questions, interpretation of, how the offer to purchase or some other form ought to be applied to a particular fact pattern. Landlord tenant, always a popular category, even more so these days with the eviction moratoria we've been living through. Disclosure, also had 2 of those, 2 that I called property management questions, 1 ethics question. Oddest question I characterized as real property, and it had to do with apparently a neighbor mistakenly planted a bunch of trees on his neighbor's property. And then when the neighbor went to dig them up, the person on whose property they planted the trees say, no, those are mine now. They become fixtures when they're attached to the land, and so now they're mine. So that was an interesting question. One license law question, one MLS question. One of the contract questions is one I want to just mention because it's something we're getting a lot of questions about. And again, it's driven by this market we're in. What happens when a buyer enters into a contract sight unseen? I had one yesterday. The buyer entered into a contract sight unseen, and then they went to look at the property and they said, we don't like this property. There's something wrong with it, and I've forgotten what it was. And they refused to pay the due diligence fee. And, and they claim that they didn't have to pay it because the property was misrepresented in some way. And it occurs to me that if you're going to enter into a contract sight unseen, and the thing that you're complaining about is something that would have been readily ascertainable had you done a physical examination of the property as you normally would before you made an offer, you may not have any basis for claiming that there's been some misrepresentation about the property, even if there has been a misrepresentation or an omission of material fact, because you've got to show that you reasonably relied on that misrepresentation or omission. It's going to be hard to prove reasonable reliance if this is something that would have been apparent to you had you viewed the property before you made your offer and entered into a contract sight unseen. So that's kind of an emerging issue. I think you need to be careful if you're a buyer agent, I guess in particular, in making offers on behalf of buyers sight unseen. There's nothing wrong with it, but it's definitely an area of risk for buyers and I think also agents involved when questions come up. Had a question about escalation clauses yesterday. Fairly typical questions I got. Questions I didn't get. I didn't get one about the clear cooperation policy. Getting a lot of questions about that. Didn't get a question yesterday about the backup contract addendum. Getting a lot of questions about that addendum, which has become much more widely used, again, because of the market we're in. And I didn't get a question about assistance animals. That's probably the most common fair housing question we're getting these days. We just get bunches of those. So anyway, that's all I've got. Thank you for your time. I'm going to turn it back over to Kelly now.
Very good. Well, thank you very much. And always interesting to hear not only what you have to say, but also the types of calls that are coming in over the legal hotline. I want to say before I turn it over to really to both Will and Alexa and the floor for any questions. As NC Realtors president, I do get calls from our membership. I'm always delighted to take those. It's very interesting to hear what they have to say and what some of the problems are. One is particularly disturbing, and I know it's certainly the case in Greensboro, and that is many listing agents, and this is a complaint I've been receiving around the state, but I know what's going on in Greensboro. And that is listing agents are not contacting the selling agents promptly, and many times not even at all, not whatsoever, once they've received an offer that's been accepted by their seller. So what happens is, and two of the calls I've gotten recently, their clients who are buyers are calling their buyer's agents saying, have you heard anything? Have you heard anything? And they're saying, no, I haven't heard anything. I guess we're still in it. And only to find out that another offer had been accepted. It'd been a day or two later, and still no comment, no reaching out by the listing agent saying that the offer has been accepted. So what it does is it certainly makes realtors look unprofessional. It also makes them look very insensitive to their own buyer clients and the type of excitement and urgency they have in finding out if in fact they have secured the property in these many multiple offer situations. So I would ask you to speak with your agents about that, because again, it's embarrassing. It's embarrassing. I know it takes time. I had a property that garnered 28 showings and 17 contracts in a 2-day offers in a 2-day period. I still took the time to either call or personally email every single one of those agents, thanking them for their offer, and also telling them if there was a particular element in their offer that put them out of it, or whatever the case may be, if it was particularly close, because so many of the offers were over list price. So at this point, I'd like to open the floor up for question and answers for today's speakers. And if you would go ahead and drop those in the chat field, we'll do our best to get them as far as to the parties. I do have one that has already come in, and this is really for Will. And that is, Dawn wants to know if the Code of Ethics, number 29, applies to non-licensed staff. So Will, what say you?
I would say no. The code applies to realtors, not their unlicensed staff.
Okay.
But it's of course I have to make it complicated being a lawyer. It's an it depends answer always. I suppose if you were a realtor who was in charge of supervising that unlicensed assistant, and you permitted them, to continue, using hateful speech in connection with one of the 9 protected characteristics on their social media page, you might get a little too close to the fire and get pulled into a violation yourself because of a lack of supervision.
Very good, Will. Thanks so much. Lecture, as of last week, we've had over 320 realtors complete the Fair Haven. Do you have a ballpark of how many realtors nationally have completed the Fair Haven since its launch in November? And what do you think has been the biggest success of the Fair Haven so far?
I haven't checked the numbers this week, but the last time I looked, it was around 10,000. A lot of folks are doing big promotions around it for Fair Housing Month, so I'm hoping that number is going to go way up. We also just this past week updated it, so now it has a certificate of completion, and we're creating a tool so that brokers and associations can pull reports and see which of their members have completed the simulation. So that's all going to be coming online for April. I think the biggest success is, in the feedback we've received, we had this goal of provoking an emotional reaction and teaching people on a deeper level. And the feedback we received is telling us that we have accomplished that goal, at least with regard to some folks. So I think that's a big deal.
Very good. Thanks so much. And Will, look, from a risk management standpoint, and this is one of the emerging issues for NAR and serving on the committee, which I do, we know that love letters have been a hot topic for a while now, but how should we be advising our agents regarding using them with their clients? And Alexa, I'm going to ask you, after Will comments on this, what you can also give us some advice on the love letters from a fair housing perspective.
Kelly, I'm discouraging their use at all, and encouraging agents to discourage their buyers from attaching them as part of their offer, whether they're attached or not, and encouraging listing agents to have a conversation with their sellers about it, and really preemptively decide that you're not going to look at them. There's just, they most of the time, I would say, contain personal information, and they reveal characteristics of the buyer, which could then be used knowingly or through unconscious bias as an unlawful basis for a seller's decision to accept or reject an offer, or there's a perception that they affected the seller's decision to accept or reject an offer. So I really think they're a bad idea. They're not per se illegal or unethical. And if your buyer's going to insist on including one, you can't stop them. And unless you say, I'm going to resign, it seems a little extreme. The buyer ought to understand that it's at least possible that the seller won't ever read it. But if they do insist on including a letter, they should take care to focus on features and benefits of the home itself and avoid specific needs of the buyer or other information that may be related directly or indirectly to one of those non-protected characteristics. And I'll tell you this, it was an eye-opener for me. I'm involved in a listserv of local and state association attorneys that NAR hosts. And there was a discussion not too long ago. I don't know if any of states have done it or if they're talking about trying to set up their contract form so that the name of the buyer will not be available to the seller out of fear that the seller might use that as their name as a basis for deciding whether to accept or reject their offer, or there'll be an allegation that the seller used the name as a basis for accepting or rejecting the offer. So it's like, wow, the name of the buyer. It's hard to even imagine how you've got a binding contract if you don't have the name of the parties in the contract. But my point is, it's very serious, this issue.
Alexa?
Co-sign everything Will said. NAR strongly discourages the use of love letters. When a buyer is encouraging a seller to choose them based on their personal characteristics versus the merit of the offer, there's a lot of risk there that they could stray into revealing characteristics that are forbidden under fair housing laws to make a housing decision based on. We haven't banned it, but we discourage it. And to Will's other point, there's a scenario in Fairhaven, and we've seen a real fair housing case where a seller backed out of the offer after seeing that the buyer's name was Ebony. And there are internal discussions about, is it possible to mask the identity? But then there are other concerns, as Will raised. Is that even a binding contract? So these are things that we're aware of, we're talking about, and we're working towards solutions for.
Well, I know that, and again, serving on risk management, when this came to us is really an emerging issue. And 3 states, including California and New York, have addendums concerning buyer love letters. Is the case in California, which, if I can recall, maybe not exact, but pretty close, is that it was a multiple offer situation. The sellers accepted the offer that submitted a buyer love letter. And it was a buyer love letter that identified, as far as with the sellers, both from a familial standpoint, from a religious standpoint, and mentioning celebrating, Christmas, Easter, holidays that, for example, certainly, weren't Jewish or other cultures, for example. And when it got out that is one of the reasons why the seller had in fact accepted that, it provoked a lawsuit from someone who was single, who wasn't married, who didn't identify with those religious similarities, and sued for basically because of being discriminated against. And what was interesting about that, not only did they sue the agents involved and the firms involved, but when it went to the Arizona emissions insurance companies, they said, sorry, that's a discrimination case and you're not covered for that. You guys are on your own. And which is rather daunting when all of a sudden there's a lawsuit and everything dollar for dollar is coming out of your own pocket. So I know that same thing we have, as far as from committee, been discouraging it. We tell them that we will not be the courier of whether an agent, as far as getting those to a party. And while we can't stop them if they want to tack it on their front door, stick it in their mailbox, I would say to this, don't put anything in there that has anything to do with protected classes or anything dealing as far as it personally. If someone wants to talk about how well the house is kept and bricks and mortar and a nice lawn and perhaps what great neighbors they're going to be because they have an open door policy and throw all these parties or whatever. You have less like there's no discrimination on that, but it's a very, very fine line and something that, again, from an emerging issue standpoint. We have another question, and this is dealing with Jeremy has a property will that has a deed restriction from 1940 that includes a reference to allowed races living on the property. And we actually had a situation like that here in Greensboro. I understand we have a duty to disclose, but what would be your response to a potential buyer with the deed restrictions such as that? Seems it would be illegal.
Yeah, I don't think so. That's clearly an unenforceable restriction. I've even talked to the Real Estate Commission about that several months ago, and they didn't have any problem with the agent, posting the restrictions that contained this blatantly unenforceable restriction, old restriction. I mean, I would say, this gets into a very interesting question we could talk about for a while, but I don't think, as a listing agent, you've got an affirmative obligation to, publicly display these restrictive covenants in connection with the listing. And you might want to be extra sensitive to that if you're posting, old restrictions that contain something that's blatantly illegal. Just don't post it, but I mean, you're not going to get in trouble for making those restrictions available to an interested buyer. They're historical record, I mean, they're not, to me, I just don't see how that could be taken as an indication that the listing agent or the seller has any intent to discriminate.
Okay, and there's also another question about amending the due diligence money in the offer to purchase, since it currently states with a contract. Has that been brought up before?
Oh yes, we've talked about that. I won't get into that, but yeah, we still want to get the due diligence money into the seller's hands as soon as possible, and we haven't figured out a better way than to make it payable with the contract, although we understand that it's typically not going to be there immediately upon the effective date. We hope that enhances the possibilities that the seller's actually going to get it, because unfortunately it's not at all an uncommon situation where the seller accepts a contract and then the buyer, usually it's fairly quickly, thank goodness, but they say, you know what, we've decided we're not going to go through with this, and they don't pay the due diligence fee. And the seller can get out of it fairly quickly, but they've perhaps lost an opportunity there to accept the offer of a different buyer. And so we are doing some things to try to enhance the ability of the seller to actually receive the due diligence fee. So we're doing some other things, but that'll come out in July if the changes are approved. But we haven't changed the time that the due diligence fee is due and payable.
Okay, very good. Alexa, we mentioned earlier in the session that you and Brian Green are both helping us to develop our new Fair Housing video series. And certainly thank you very much for helping create this new resource for our members. But I want to ask, though, if you could name one thing that our BICs should focus on enhancing or implementing this year within their firms regarding fair housing, what would that be?
Well, I think you lead by example, and the message that fair housing violations won't be tolerated has to come from the top down, and it has to become a part of your firm's culture. And it's not something that you do once a year or when it's required, but it's something that's woven into the way you do everything. So I think, this initiative that your state association is promoting, where you will have resources to provide to your agents at monthly meetings, is a great start. We also have, best practices in our brokers essentials manual, like creating a fair housing compliance program at your brokerage. So make sure that you are following that guidance.
And when it comes to implicit bias, can you give a couple of examples where you might see this at a firm level, again, since we have the broker in charges here? And how can our BICs make sure that they as managers are not showing biases?
Well, don't make assumptions. Listen to people. Let them guide you. So don't assume that because a client is of a particular background, they necessarily want to be with an agent of that background. Also, an example is being uncomfortable when working with someone from a different background. So and then that makes you sort of clam up, and then even though you don't intend to treat that person differently, you are, because you feel uncomfortable. And so the best way to break down biases against other groups is just the number one way is to have sustained friendships with people from groups that are different from yours. Go into other communities, get to know people, get your comfort level up. Also, if there are situations where you anticipate you're going to run into difficulty and you're going to feel uncomfortable, develop a script beforehand and practice it. Now your comfort level is going to be increased.
Very good. And I don't see anything else posted right now, either for Lex or you, Will. So thank you very much for your participation and your great comments and participation today, as well as your time. I wanted to go ahead and put a plug in for the North Carolina Realtors Technology Hotline. I know we have many of the brokerage firms out there that have the resources and have in-house tech people. I would like to remind you, though, that the NC Tech Hotline is a service provided by NC Realtors and for the benefit of the membership. Their average hold time, for example, is 30 to 60 seconds. I don't know if in-house personnel can get to your realtors and members that fast. In addition, they're open from 9 in the morning till 8 o'clock at night, Monday through Friday, and 9 in the morning to 5 o'clock in the afternoon on Saturdays. And they can help your agents with, of course, taking over their systems, and for as many systems as that they have, and going into their systems, whether it be laptops or desktops, to look and fix their problems. They can help with wireless issues. They can give you recommendations as far as on printers and other peripherals and main equipment, almost like a consumer report person that is live. But they also can help you as far as with other services, for example, cutting the cable in your home, helping you set up a smart TV, helping you stream everything in your home, helping you even sync your car to your phone and your car to your garage as far as with the visors. So please take advantage of that. It's a great service, again, provided by NC Realtors. They'll go ahead and post the again, the NC Technology Hotline. When you call, that's how they answer it, so they know that the members are a member of NC Realtors. Second also is some of our realtor partners. And I suggest, again, many of your agents certainly will be buying their own supplies. Office Depot is a good place to go. I go there, and it is amazing how much it takes off. I went the end of December. I bought a couple packs of ink for my Hewlett-Packard printer, as well as some paper. It took $60 off my bill. Whenever I buy ink, again, for the printers, it takes somewhere between $15 or $20 off that one purchase. So the thousands of products that are discounted, it's a great way, again, to provide a great service for your members and at the same time save them money. I don't see, again, at this point, any other questions. So at this time, I guess that's it. I certainly want to thank everyone involved, Alexa, and of course, Will. Thank you so much for your participation. All the brokers who attended today, and George, thank you for spending the time and going back and sharing the messages with your firm and all the association executives. Thank you so much for what you do. We couldn't do what we do without you behind the scene. And I'd like to give a shout out to Rachel Branson and Mackenzie Allen, who have also been instrumental in putting this on today behind the scenes as well. So again, thank you guys so much for your participation, and everyone stay safe, continue to wear your mask, get your shots. And again, thanks so much for being members of NC Realtors. Take care.
Thanks, Kelly.